Now that we've broken down alienation of affection, let's talk about the spicier sibling, criminal conversation. If you haven't watched my Alienation of Affection 101 video, please go watch it because I lay a great foundation there. I give you the origins, the difference between the torts, what a tort is, all that information is in that first video. Alienation of affection has to do with interference in a relationship. Criminal conversation is the spicy sibling, like I said. And you can't really go based off the name alone because criminal conversation implies talking about crimes. No, that's not what this is about. It's just an old school term. We'll get into that later. So let's begin. What is criminal conversation? It's actually one of the simplest torts in North Carolina, and it's laser focused on one thing: hanky-panky with a legally married person before a permanent separation. And that's it. The act of schmexual intercourse itself triggers this claim. I'll show you. What I'm showing you here are the official North Carolina pattern jury instructions. This is public record. I found it on the UNC School of Government website. It also houses a copy of the NC General Statute that governs criminal conversation, that is 52-13A. I'm not going to read you all of that jargon. We're going to jump into the 3 things that the plaintiff must prove. The first one is at the bottom. During the marriage, the defendant had hanky-panky with the plaintiff's spouse. Second is that the hanky-panky happened before the plaintiff and spouse physically separated with the intent that the separation remain permanent. And lastly, that any evidence from after the permanent separation is considered only to corroborate conduct that happened before the separation. And here's where criminal conversation differs dramatically from alienation of affection. The law removes almost every question people think matters. There is no need to prove the defendant knew the spouse was married. There is no need to prove more than one encounter. A single act is enough. There is no need to prove the spouse didn't consent or initiate anything. There's no need to prove the marriage was loving or affectionate, or that the couple hadn't emotionally separated. There's no need to prove the plaintiff was perfectly faithful. The act of hanky-panky itself triggers the claim. And the reason for that is rooted in how North Carolina views marriage under the law. North Carolina treats marriage as a legally protected relational interest, meaning the state recognizes certain rights and expectations that flow from a marital relationship, and schmexual access is one of them. I'm going to cite my source here for context. Please view Sebastian versus Klutz. This is NC App 201 from 1969, which describes marriage as a valuable and legally protected relationship. So when adultery occurs before a permanent separation, the law automatically recognizes it as a harm to that protected relationship. But, and this is the nuance people miss, strict liability does not automatically equal massive damages. So let me give you a clean, practical example. Let's say person A meets person B at a bar. Person B says they're single, acts single, lives separately, and even uses the word divorced. They sleep together one time. Later, person A finds out that person B is still legally married. Can the spouse technically sue person A for criminal conversation? Yes. Does that mean a jury will hammer person A with a huge judgment? Not necessarily. The jury still has to consider, was this a one-time encounter? Did the defendant genuinely not know? Did the act meaningfully harm the spouse? Is this worth compensatory damages, or should punitive damages apply at all? Strict liability triggers the claim, but the jury determines the consequences. So this is the perfect moment to connect all the dots. In the Akira versus Brenay case, the law protected the marriage between Tim and Akira by allowing alienation of affection and criminal conversation to move forward. But it was the jury who contextualized the conduct. They are the ones that looked at the entire picture in proper context to determine what damages should be awarded, if any. They reviewed all the evidence together, the messages, the videos, the timeline, the testimony, and determined that harm was done to the tune of $1.5 million for alienation of affection and $250,000 for criminal conversation. That should tell you something about the strength and weight of the evidence that was presented in court. So now that you understand what criminal conversation is, a simple yet often misunderstood tort, tell me what you think in the comments. Do you think this should be law? Or do you think this is something that should be held between spouses? Do you think it's something that only the spouse should be responsible for? I will be reading in the comments. Please keep it respectful. I hope you liked this breakdown. If you have any questions, I will do my best to do the research and answer them to the best of my ability. And if not, I will see you in the next video.